Hey everyone, Harry here to talk about Donald Trump's appeal in the Second Circuit of his second removal motion in the New York case. So let me set this up a little. It's become extremely convoluted procedurally. But way back at the beginning of the New York case, the one that resulted in convictions, he moved to remove the case, that is, to bring it under state law, but in federal court. And the removal law says that you can do that basically when you're being charged criminally by a state for doing something in your official duties. It's similar to tests we see in other areas, but the basic notion is from way back when we're worried about states trying to criminalize the conduct of federal officials who are just doing their job, and we're going to permit them to go to a presumably more sympathetic and fair federal forum, even though you'll still try the case under state law. It's just the actual judge and, to the extent it matters, jury pool, which is a little bit different. Okay, so Trump moved to remove the case, and importantly, he abandoned that effort the first time around at the appeal stage. He really did it strategically. It had to do with other motions he was bringing and wanted to protect in certain positions, but the main thing is he did not pursue it. And basically abandon it. Then, after he was convicted and after the Supreme Court had issued its ruling in the immunity case, he tried again, a second removal motion, and he started it before Judge Merchan. But in that situation, when you've done it before, you need to jump through certain procedural hoops and make certain showings. And the judge ruled that he hadn't made those showings. So even though his motion makes it seem like it's just on the merits, the basis for denying the second removal is more narrow, more procedural. Now, we'll see if the Second Circuit accepts his invitation to view everything more broadly, but they certainly have the option to just say, no, you abandoned this before and you didn't really give us a good reason for your second bite at the apple, so you don't get it, end of story. However, Trump is throwing everything in to this motion now in front of the Second Circuit and basically making a broad argument that for multiple reasons, many of which really are just not at issue in any technical sense in front of Judge Merchan, he should be able to bring this to a federal forum, and a big part of it, the immunity opinion itself. So he wants to say this intervening opinion has changed the whole course of things. For that, among many reasons, he actually says there's a whole series of different reasons which combined give a special argument. That's the sort of argument, by the way, that when an appellate judge sees it, they're likely to kind of be a bit cynical, because that sort of suggests that the individual argument that is really at issue doesn't add up, and they're trying to kind of combine and glom on to other legal points. And that really is what Trump is trying to do. Now, recall, as part of this whole complicated procedural landscape, he already is raising the immunity issue before Judge Merchan in the trial court. So he said to Merchan, and there's a motion pending, that the case ought to be thrown out because it used in part, this is really a small part of the evidence. Remember, I was at the trial, but there was a little bit of evidence that was conversations between Trump and a government official, because there was one conversation when he was president with his communications director in the White House, and that sort of corrupts and pollutes the whole thing, and it should be thrown out. And in addition to fighting that on the merits, the New York DA, Alvin Bragg's office, has said it would be harmless error anyway, even though the jury had this evidence in front of it. So the whole immunity issue is playing out already in the district court, and it would be very sensible for the Court of Appeals to say, look, all this immunity stuff that you're now trying to throw into the mix, that's got a separate track. We'll let Justice Merchan decide what to do with that, and then we'll take it up. But for now, your attempt to revive your second removal effort, that doesn't fly because the reasons were well taken that you hadn't gone over the threshold for reviving a removal motion and trying to take it a second time. So the Second Circuit has a lot of possibilities. We'll see what the DA's office says in response, but you can imagine the Second Circuit, depending on the panel, trying to take account of some things that really technically are outside the box here for the specific question presented, which is, should he have been allowed to bring his second removal motion, or was there good sound procedural reasons for not letting him? That's what's really there. That's what you would think a Court of Appeals would focus on. But Trump is trying to broaden it considerably, and that's an invitation. We'll just see whether they accept. My best guess is they won't. They have an easier way to dispose of this case, and they can still think about the immunity opinion and its implications down the line after Merchan makes his ruling. But we will wait and see where the Second Circuit goes, and also wait and see what Bragg, the DA, has to say in response. So there you have it. Trump, like a fly in a spider's web, trying to get out of the case overall before he is sentenced, which is now scheduled for November 26th. And bringing a motion in front of the Second Circuit to revive a second removal motion that was denied for pretty sound procedural reasons that I would think would hold up on appeal. But in the Trump world, and particularly where immunity is concerned, you always have to allow for the possibility of an idiosyncratic decision, especially by an appellate court. So we'll wait to see what Bragg has to say, and then the Second Circuit. It will not be happening soon. It will not be before his sentencing takes place on November 26th. And in that sense, it will be in a different world, including a world in which there remains a possibility, a harrowing, sobering, terribly problematic possibility that Donald Trump will be president. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.